Hello students, today we are going to discuss religion and state relationship and its implication for right to equality. This unit would enable the students to understand the relationship between religion and state, the various constitutional provisions, and religion and its implication for right to equality. Constitutionally, typically regulates the relationship between state and religion. Some established connections between the state and a particular religion or religions, or even give religious laws or institutions a privileged position and place in the legal system. Others declared the secularity of the state or seek to protect the neutrality of the state from any religious institutions. However, the social context has a bearing on our understanding of the relationship between the state and religion in India and its implication for right to equality. India is an ancient land of religious plurality and cultural diversity. The largest democracy in the globe is a federation of 35 constituents, 28 full-fledged states and 7 union territories, 2 of which are self-governing and the rest ruled by the central government. The Hindu religion is predominant in as many as 29 of these constituents, its followers having a nearly 80% share in the country's population of over a billion. There are 160 million Muslims in India, with the predominant Sunni majority are the country's second largest minority. There are an overwhelming majority in Kashmir and Lakshadweep, a third of the population in Assam, about a quarter each in Kerala and West Bengal, and a fifth in the country's most populous state, Uttar Pradesh. While there is a sizable number of Muslim majority districts, cities, and townships situated and scattered across the country. With a headcount of nearly 24 million, the Christians, with a predominant Catholic majority, are the country's third largest minority. There are a majority in 3 northeastern states, Meghalaya, Mizoram, and Nagaland, and their population is much higher than the national average of 2.5% in Andamans, Arunachal Pradesh, Goa, Kerala, and Manipur. The 6, with a total population of 16 million, are the majority in the state of Punjab and a minority everywhere else. Next to them are 8 million Buddhists, having a high percentage of population in Sikkim, Arunachal Pradesh, and the Ladakh area of Kashmir, followed by a 3.5 million Jains scattered all over the country. For many people around the world, religious identification is an integral part of their communal and national identity, which some may seek to express through constitutional recognition. A desire to acknowledge and protect religious diversity in a society may also incline constitutional designers to give special recognition to various religious groups, and India is no exception. Now we come to this complex relationship between state and religion. In 1843, Karl Marx announced, "Religion is the side of the oppressed creature, the heart of a heartless world, just as it is the spirit of spiritless condition. It is the opium of the people." And it appeared that a little more than 100 years later, many Westerners had done away with their religious habits. Shortly after Marx, God's obituary writer Friedrich Nietzsche famously stated that the death of God and that we have killed him. And by the 1960s, religion was indeed supposed to be dead. In 1967, Martin E. Marty suggested that spirituality as a topic of public discourse has been abandoned in that decade. However, religion turned out to be this great vanishing act of the 20th century, reappearing in a flood of fanaticism and intolerance. The past 2 decades have seen a dramatic resurgence in religious interest, and religious minorities have been at the center. Therefore, not just India, but many countries around the world have tried to accommodate the interest of different religious communities in order to maintain peace and harmony. The majority of Indians have never favored a theocratic state, but there has always been in the country undercurrents of thought suggesting a space for religion in state affairs. Until the beginning of the 20th century, India's war for independence from foreign rule was fought on the planks of equality of all faith, traditions and their followers. The scene changed thereafter, and certain sections of the majority community began projecting their religion as an inseparable part of the future political ideology. As a reaction to this, some Muslim leaders began demanding special arrangements for their community in the country's forthcoming political structure. These competitive aspirations eventually led to the partition of the country, accompanying its independence from British rule. After independence, the constitution-making process stressed on the protection of certain religious traditions in the national character under preparation, and some of these had to be accommodated in the context of the multicultural composition of the country. A quasi-secular ideology remained dominant in state affairs for about half a century after independence. But throughout these years, certain concessions had to be periodically made in favor of particular religions. Towards the fag end of the 20th century, the majority community's protagonist of a different ideology that they called Hindutva took over the reins of the nation, and the ideology of cultural nationalism remained dominant in the country's governance. Therefore, existence of these two competing political ideologies, one believing in the principle in equality of all religions and the other in the privileged position for the historically oldest religion of the country, seems to have become a permanent feature of Indian polity. On the whole, the favored ideology regarding the state-religion relationship in general is of a liberal cooperation, not of a rigid separation. In a leading case, the Supreme Court of India stated that secularism is more than a passive attitude of religious tolerance. It is a positive concept of equal treatment to all religions, asserting at the same time that when the state allows citizens to profess and practice religion, it does not either explicitly or implicitly allow them to introduce religion into non-religious and secular activities of the state. Regulating the relationship between state and religion, between civil and religious authorities, and between secular and sacred codes of law has historically been and continues to be one of the most challenging functions of the Constitution. Another important function of a Constitution is to ensure peace and justice between all members of society, even in societies that are marked by deep religious schisms. Yet in many parts of the world, the relationship between state and religion continues to be one of the most difficult issues for constitution builders to resolve. A particular religion may be associated with national identity or with the foundational values of the community. Public opinion may be expressed through parties that are motivated by or identified with a particular religion. These situations can give rise to demand for religion to be given specific constitutional status. There may be religious minorities who seek special protection, including the right to have personal matters governed by their own religious laws, resulting in an asymmetric constitutional framework. Such moves towards the constitutionalization of religion are likely to be opposed by those who believe that religion is essentially a private matter of conscience and that differences are best accommodated by combining universal freedom of religion with protection against discrimination on religious grounds and with the state maintaining neutrality in religious matters. In practice, it can be difficult to achieve agreement or compromise on questions in the design of the constitutional text, in part because the issue involved concerns matter of personal identity and deeply held principles that are not easily negotiated. Therefore, the question of whether and how religion should be incorporated, or conversely whether the state should be unambiguously secular, should be carefully and contextually considered with reference to prevailing political, historical, and cultural circumstances. Now we come to the various constitutional provisions. After independence, the Constitution of India did not declare any religion to be the state religion or an otherwise privileged faith religion. It declared equality of status and opportunity to be one of the basic ideals of future polity and non-discrimination on the basis of religion, one of the people's fundamental rights. 26 years later, the preamble to the Constitution was amended to add the word secular to the prefatory description of the character of the country. However, the concept of secularism adopted under the Constitution was and remains quite different from its Western stereotype. In the Indian Constitution, there is no US-style non-establishment clause erecting a wall of separation between state and religion, or no space for the French doctrine of Lecite. Religion has no substantive role to play in the affairs of the state, but there is no ban on allowing it a ceremonial role in state functions and official events. Conversely, the state is not at all prevented by law from playing a role in the affairs of religion and has in fact always held a pivotal position in the areas of social life of men. As regards religious freedom, the preamble to the Constitution speaks of the sincere resolution of the people of India to secure themselves liberty of thought, expression, belief, faith, and worship. The chapter on people's fundamental right guarantees to the individual freedom of conscience and the right to profess, practice, and propagate religion, clarifying that this right is not absolute and can be restricted by the state in the interest of the public order, morality, health, and other provisions of the Constitution. At the same time, all religious communities and every denomination thereof are guaranteed freedom to manage their own affairs in religion, acquire and manage property, and establish institutions for religious and charitable purposes. The Constitution, however, makes it specifically clear that these guarantees for religious freedom will not disqualify the state from introducing social reforms by law or from regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practices. Though the Constitution does not specify any preferred or privileged religion, there are in some special religious-based provisions relating to the majority community. Its chapter on people's fundamental right declares that untouchability, an age-old practice associated with Hindu religion, to which the high caste people have to keep a distance from members of the so-called lower caste, is abolished and its practice in any form is prohibited. Also, on the other hand, the chapter on directive principles of the state policy under the Constitution directs the state to protect by law the holy cow without, of course, a mention or reference to Hindu reverence of it. Moreover, denominational Hindu temples in two South Indian states, Kerala and Tamil Nadu, must, by a constitutional decree, receive prescribed subsidies from public funds. There is no provision in the Constitution reflecting states' neutrality to religious issues, nor does it specifically ask the state to cooperate with the religious communities in respect to their faith affairs. The decree is only for non-discrimination between people on religious grounds. The silence of the Constitution on this issue is taken as a tacit approval for state intervention in religious affairs of all communities, and all organs of the state, legislative, executive and the judiciary, have accordingly been taking active interest in such affairs in a way that may be inconceivable under a rigidly secular political setup like USA. Nowhere does the Constitution say or even remotely suggest that religion is to be the foundation or source of state law, nor is there such provision for religion in any legislative enactment. Parliament and state legislatures are empowered to make laws in the areas of personal statutes, family relations and religious endowments, shrine management, and organization of inland and overseas pilgrimage, without saying that there are to be drawn on religious sources. But in practice, religious tenets are usually kept in mind while enacting such laws. The judiciary has in several cases interpreted constitutional provisions relating to religious freedom to lay down its strictures and margins. A distinction has been made between essential and non-essential practices of religion, holding that the Constitution necessarily protects the former and not always the latter. In many cases, the judiciary itself has dwelt on religious beliefs to determine if a supposedly religious practice is essential or not. The problem, however, is what is essential for one community might appear detestable for another community. A crucial observation of the Supreme Court of India in this regard is worth noting. The right to religious guarantee under Article 25 and 26 is not absolute or unfettered right. They are subject to reform on social welfare by appropriate legislatures of the state. The court therefore, while interpreting Article 25 and 26, strike a careful balance between matters which are essential and integral part of religion and those which are not and need for the state to regulate or control them in the interest of the community. Now we come to our understanding of religion and its impact on right to equality. Religion has been used as a divisive force in society. It is a means by which communities have been mobilized and engaged in fierce intercommunal conflicts. It has resulted in the loss of life, property, and has been an obstacle to the maintenance of a stable environment necessary for the development of the country. Religion has undoubtedly been used to create mistrust and ruptures in society, and superstition and dogmas have been sanctioned in the name of religion. Therefore, a constitution that guarantees right to equality as a fundamental right to all its citizens is at odds with the use of religion as a divisive factor in the society. The problem is that religion is a source of personal identity, and membership of a religious community is valued and desired. In everyday life, religious differences in society are manifest in many different ways, from dress code, food habits, religious festivals, and different places of worship. However, structures of inequality were embedded in the personal law of different religions. Therefore, the provisions of the Constitution pertaining to right to equality, Article 14 to 18, which stresses on equality before law and equal protection of law, along with provisions of non-discrimination, is handicapped by the fact that the state needs to uphold the personal laws of all these communities. A uniform civil code that will further strengthen India's nationalism and shall also make a great impact in addressing issues of inequality, which is very often considered to be the product of archaic personal laws prevailing in the country, has been argued by the political elites. The proponents of a uniform civil code argue that it will not encroach upon the religious freedoms of the communities, but shall only curb those religious practices and customs which are violative of human rights and dignity of individuals. However, opponents argue that adopting a universal civil code would lead to tyranny of the religious majority by unnecessarily imposing an alien law on the minorities. They view the imposition of a uniform civil code as a cultural genocide, which has a great propensity to create communal flare-ups across the country. They argue that a more effective way to ensure national unity is by reassuring the religious and ethnic groups that their personal laws will not be diluted and shall be respected. They argue against the illusion created by the proponents of a uniform civil code that there is a logical contradiction between the idea of a nation state and a system of different personal laws. With this, we come to the conclusion of our discussion. Contemporary states exhibit great discrepancy in the formal relationship between religion and politics. Some level of interweavement of religion and politics in modern state is the rule, while a strict institutional separation between the two is a departure. Most states entertain complex relationship between religion and politics, in that they, for instance, allow for religious instructions in public schools, provide public subsidies for private religious schools, recognize religious holidays as state holidays, provide welfare through religious institutions, grant tax breaks to religious organizations, allocate to religious institutions and authorities time in public broadcasting, and maintain or subsidize buildings and venues used or owned by religious institutions. These arrangements are prevalent in most societies, irrespective of the majority religion. They are done with the view to accommodate the vast majority of religious, ethnic, linguistic communities that compose the diverse population of the country. A process to give equal space and opportunity to every individual belonging to different communities, so that the possibility of tension between communities can be mitigated. This process can be found around the world, whether the majority religion is Hindu, Jewish, Muslim, Christian or otherwise. Thank you.